The next case is Phillips versus Regina Healthcare. Each party will have 15 minutes to present their argument today. These ballot members are up to 5 minutes. How long would you like to reserve?
3 minutes, Your Honor.
All right, what you'll note is we do that, the 15 minutes will be running down when that top circle gets to 3 minutes up and you're into your rebuttal time.
Okay.
All right. The arguments are being recorded here today. A couple things, please introduce yourself when you start speaking. Please make sure you stand there at the podium so we don't lose you on the videotape, and please make sure you speak in a clear, loud voice so the videotape can pick you up. In this case, I don't know, well, there may be some use of initials in this case if there's any victims or folks involved. Please make sure that you do that or you refer to them in some other capacity rather than by their names. The judges have read your briefs and are ready to prepare when you are subject.
Thank you. May it please the court, my name is Mark Owens with Grubb & Associates, and I represent the appellant, Ashley Phillips. This appeal asks this court to decide whether the trial court erred in denying Ms. Phillips a trial before a jury of her peers when she presented extensive testimony and other evidence, when viewed in the light most favorable to her and not to Regina, show at a minimum, and I'd say at a minimum, genuine issues of material fact. Where here you have two much larger, intimidating STNAs that ganged up on, verbally assaulted Ms. Phillips. You have police reports that document what happened. You have a situation where Ms. Phillips and her white co-worker, Brittany Frazee, were both constructively discharged or terminated, while the other two that instigated the incident, Mercedes and her sister, Brittany Baker Terrell, were both just merely verbally counseled and retained. You also have an uncontroverted or undisputed expert report from a nationally renowned author and consultant, Timothy Demoff, where he very strongly established to a reasonable degree of professional certainty that Regina failed to follow industry standards or practice in doing any sort of real investigation. Matter of fact, they didn't even interview the victims. This investigation did not involve even interviewing Ms. Phillips or Brittany Frazee regarding what happened. I would posit to you that this is an abuse of the summary judgment process and should be reversed by this court for the many reasons we've briefed, and many of those I will touch on today as well. For the first assignment of error, negligent hiring, retention, and supervision, there's no question here, or at least there's a genuine issue of material fact as to whether Regina knew or had reason to know that Mercedes and her sister were bullying and harassing other employees, most specifically our client, Ashley Phillips. And we know, as a matter of law, that harassing behavior on the basis of race and or national origin constitutes per se incompetent behavior. Mercedes called Ms. Phillips and Ms. Frazee awful names such as white bitches, white crackers, things of that nature. And we know that incompetence relates not only to the employee's lack of ability to perform job tasks, but also to the behavior that they exhibit on the job, which is an opposite to the task that the job involves. Here, Mercedes bossed Ms. Phillips around. She refused to provide assistance. She made threatening comments about desiring to punch other residents in the presence of Ms. Phillips. She was disrespectful and rude. And of course, the verbal assault and the racially derogatory terms that were spewed at Ms. Phillips, and the incident that culminated in the constructive discharge of Ms. Phillips.
Prior to January 14th, has Ms. Phillips made any report to anyone at Regina, supervisor or anyone else, that these, I'll call them intimidation attacks like you were trying to describe, had occurred prior to the 14th?
Yes, she did. The evidence in the record shows through her testimony and I believe also the testimony of Mary Freeman that Ms. Phillips did go to the charge nurse and also to her direct supervisor, which was nursing supervisor Mary Freeman, to complain about this behavior by Mercedes, the fact that she was being harassed by Mercedes and treated this way. And Ms. Freeman, she admitted in her testimony, did nothing about it. She didn't take it anywhere, didn't take it up the chain or take any action whatsoever. We also have the issue of pre-employment background checks for Mercedes, which clearly showed she lied on her employment application. she did not work for the periods of time that she said she did. That should have been a red flag to Regina that there's something wrong here. And it's irrelevant. The trial court, we believe, wrongly focused on the fact that Ms. Baker-Terrell had not necessarily previously engaged in conduct similar to that which resulted in the big blow-up. However, that is not necessary. We would say that that's irrelevant here because of all the other indicators that Regina should have picked up on, including Ms. Phillips' own complaints, including the complaints of a nurse, which we cite in the brief, where she said that there was this sort of behavior going on. There was abuse. It was an abusive environment, and that nursing complaint was not investigated either by Regina.
And when was that complaint made?
That was made, let's see, it was well before this incident with Ashley Phillips. I don't recall the exact date that that occurred. I can get that for you for the rebuttal.
But counsel, in regard to that complaint about the atmosphere, bullying and everything, it was not specifically related to the two individuals here that allegedly intimidated Ms. Phillips.
Not specifically those two individuals, yeah, from the nurse's complaint. However, the abusive environment and the conduct that was occurring was something that Regina was made aware of, not only through that nurse, but through Ms. Phillips, going through the charge nurse and her nursing supervisor. And of course, we also need to establish, and we believe there's at least a genuine issue of material fact as to whether other similarly situated employees were treated differently. In this case, they were. And those two individuals specifically were Mercedes and her sister, were treated much differently. They were in the same position. They both had complaints of poor resident care. Nothing was ever done, or no discipline was ever enacted relative to Mercedes or her sister, but the other two that happened to be white were disciplined in the form of Ms. Frazee was fired, and the testimony is that actually Phillips was going to be fired. Her discharge paperwork was being written up when she submitted her letter of resignation, so she knew the writing was on the wall. Regina had already decided to terminate her, so I think the whole idea of voluntary resignation is a bit of a red herring here, which I know my opposing counsel will make a big deal of. Well, she resigned. She didn't have to resign. Well, she had just been abused. She had been treated horribly. It was so badly that she went to the police department, and nothing was done by Regina. She states in her resignation letter, "This is why I'm resigning, because Regina does not take it seriously. This is something that's been going on. I have to, at this point, walk away from this situation." And of course, you have the expert report, as I mentioned to Mr. Demoff, which is very extensive, isn't contradicted by any contrary expert engaged by Regina, which shows that there was no real investigation. Any kind of investigation was a bit of a shame here. Again, the victims were not interviewed. There are no notes in existence to substantiate Regina's claim that it conducted an investigation. And it was clear, and Mr. Demoff opined to a reasonable degree of professional certainty, that Regina failed to equally and consistently enforce its workplace policies and procedures because it treated Mercedes and her sister much, much differently than it did Ms. Phillips. With respect to reverse race discrimination, Ms. Phillips must only demonstrate by a preponderance of the evidence that background circumstances support the inference. She only needed to establish the inference, which we believe through this very fact-specific summary judgment case, with all the testimony that is there certainly are enough facts to create that inference, or at least a genuine issue of material fact, to proceed forward to trial. It's undisputed she was qualified for her position. She was treated differently, as I stated, than individuals who were black. And I'd also point out, well, if I could, I'd like to go back and point out relative to the incompetence element of the negligence claim. I just want to point out to you, and you'll see in the briefing, that Mercedes did admit, she admitted in her testimony that her inability to be timely and to help others It did cause some staffing issues with patient care, essentially her failure to come in on time. So she did acknowledge some incompetence there relative to the effect of her behavior on the work of others in the home in Regina. Hostile work environment. Again, we believe there are genuine issues of material fact here. The harassment was clearly unwelcome. It was based on race. You can't have terms such as white bitches or lazy cracker or white cracker and it not be racially motivated. Ms. Freeman sent the two STNAs involved in the incident, Ms. Phillips and Ms. Frazee, home. Now granted, it was at the end of their shift, and that was brought up in the briefing by Regina. And that's fine, it was the end of their shift, but they should have gone back then and properly investigated and properly disciplined the other two who caused the incident, which were just sent back to work and later merely verbally counseled with no other repercussions whatsoever. Mercedes and her sister used verbal and physical intimidation and verbal abuse to scare and intimidate Ms. Phillips, and they prevented her from performing her duties. This harassment was constant, severe, and pervasive, as Ms. Phillips testified. It affected her job daily. Despite knowledge of the harassment, Regina merely verbally counseled Mercedes and Brittany Baker Terrell after a woefully deficient investigation, while terminating Ms. Frazee and constructively discharging Ms. Phillips on a pretextual basis. And we stated that we used the term trumped up poor residence care allegations. Exactly what they were. You'll see the testimony establishes that this poor residence care justification was not supported by the record. There weren't supporting notes to support those allegations. Ms. Phillips testified that her signature was actually forged on write-ups. She did not sign these write-ups. So there's a lot here that needs to be evaluated by a jury, Your Honors. And with that, I would defer to my rebuttal time for any remaining.
We'll have the remaining time for rebuttal.
Thank you.
May it please the court, Jonathan Good on behalf of Regina and the FLE. The date of Denise Connor's report was not substantially before this instant on January 14, 2018. It was subsequent to it. It was on March 16, 2018. In his exhibit, which is cited in the record, plaintiff's exhibit, why. So again, that goes to, there is no actual notice of any racial motivated comments. And in fact, Ms. Phillips says this was a one-time incident, that she, before January 14th, she, Ms. Terrell had not made any racial-based comments, that this being called lazy or white or this or that was just on that day, one time, and it was made out of frustration, which happens in the workplace. Being an STNA in a nursing home is a demanding, hard job. And there's work disagreements regarding patient responding to alarms that happens routinely. That does not mean that it's racially motivated.
Counsel, I'm a little confused. So, in the depositions and so forth, then, Mercedes did admit that she referred to the plaintiff here, the appellant, and racially motivated comments.
Just because somebody, you know, if it's illegal to say you're lazy, or you're white and you're lazy, or you're black and you're lazy, if we're gonna say every time somebody says you're Asian and you're lazy, or you're black and you're lazy, or you're white, to combine, if they say at one time that is illegal, racial motivated animus, the barn doors are gonna be open.
Well, I'm
Everybody's-
just asking, did she say, okay, did she agree that she made the statement lazy white, B-I-T-C-H?
I think she admitted that she called them lazy, white lazy.
Okay, what about white cracker?
I don't think she admitted that, but I'll let the record speak for itself.
But that would be a question of fact, as we have the comments from the appellant or the plaintiff that she used the terms that your client saying, or not your client, but Ms. Terrell denying that she used those terms. Is that fair?
No, I respectfully disagree. I don't think that's fair, because even if it was a one-time utterance, it may be boorish, it may be impolite, it may be, a one-time offensive utterance. That does not make it racial harassment or racial discrimination. What we're talking about is a one-time incident where Ms. Phillips thought it was funny. She giggled. So if Ms. Phillips did not find this offensive at the time, she admits she giggled about it. This wasn't daily, it wasn't constant, it wasn't severe where it altered Phillips' employment, work environment. If it was daily, constant, and altered Phillips' work environment, then from the date of Phillips' hire in 2017, she would not be able to work. She worked from her date of hire, I believe in April of 2017, for the whole year up until January. So it did not alter her.
So when was, so you're saying Phillips worked there from 2017?
Yes.
Okay, when were the other two individuals hired?
Oh, I don't recall off the top of my head.
But they weren't there that long.
I don't recall. But interestingly, this goes to their argument that the Terrells were treated differently than Ashley Phillips. That's not true. The Terrells were subject to progressive discipline as well as Ashley Phillips. Excuse me, can I get a glass of water? It's just that Phillips' progressive discipline was farther down the road than Mercedes Terrell and Brittany Terrell's. At the time of this incident, Ms. Phillips had already had written warnings. And this
Well,
was,
I want to make sure I understand. Ms. Phillips, according to Regina, was not discharged anything related to this incident, right? They're saying she didn't treat the patients correctly.
well, I mean, she was not discharged at all. No, she resigned, okay?
Regardless of whether, the
Um,
whole point was, they were going to discharge her based on patient care.
Well, a pattern of patient care, of complaints, and the underlying dispute here was that Frazee and Phillips were not attending to the flashing call lights,
Okay.
and that
But,
was,
but my point is, you were comparing them, saying, well, for this incident, she was farther down with progressive discipline, so she was more eligible for being discharged, as opposed to the other two individuals that were just counseled according to progressive discipline. So my point was, I didn't think that Phillips was actually disciplined in any shape, manner, or form in regard to this incident.
that's correct.
Okay.
That's correct. They were conducting the investigation.
So wouldn't that lead one to surmise that Regina believed Phillips because she disciplined the two individuals that had engaged in that language?
No, I don't think that's, respectfully, I don't think that's fair. Because Phillips preemptively submitted her resignation and did not give Regina a chance to conference with her at the conclusion of the investigation.
But
Counsel, I'm a little unclear from the briefs about what happened on that following Monday. There's some argument that someone from Regina called Phillips and said, don't come in because you were afraid, and Phillips disagreed with that. What's the testimony in the record
Well,
about Monday?
I don't think Phillips disagreed with it. I think Regina's, if Phillips reported, I'm uncomfortable coming to work, and Regina says, well then, if you're uncomfortable coming to work while we conduct our investigation, why don't you stay home? And that's what, then they say something different. But whether, I don't think it matters is a genuine material fact, because Phillips came in the next day and voluntarily resigned as a preemptive, she took the decision out of Regina's hands, whether to further evaluate the situation, conduct further investigation. She cut it short, and she made that decision.
Now, the coworker, I don't remember her name right now, but Brittany?
Brittany Frazee?
Yes, she was discharged though, right? Prior
Yes, she
to the
was.
time that Phillips resigned?
Yes, and she was discharged. So, again, that, just because Brittany was discharged, I don't think creates a genuine material fact. Brittany Frazee is not a party to the suit. She has a separate employment history, a separate disciplinary history, and different facts, although it's the same January 14, 2018.
Prior to January 14, had Ms. Phillips made some complaint to Regina Health Center about the work environment and her employees being unhelpful or abusive to her?
Well, I think it was, she made reports to the assistant, or the charge nurse, and it wasn't reports of abuse. It was reports, it was general work disagreements. And there were absolutely no reports that it was racially motivated. There were absolutely no reports by Ms. Phillips to HR, according to the policy. So the record is very clear that there were no reports of a racially based abuse or harassment. It was more, they're not helping me with the wheelchair, or somebody's not doing this. There's no connection to race. I mean, some of her complaints could have been about
She
white
didn't
people.
relate to them that they were bossing her around and things of that nature?
Bossy, but again, that's pretty typical work, that's pretty typical work environment. I get bossed around all the time, but it's not racially motivated.
Well, all I asked was whether she complained that she was being bossed around.
Phillips complained that she
Thanks, that's
is
all I
being
need.
bossed around. So, a couple other things that I wanted to touch, again, they claim that there was no investigation. There was an investigation. Regina had a meeting in the office with all people involved, Frazee, Phillips, Mercedes, both Terrell sisters. There was a meeting that day in the office. So it certainly couldn't have been that threatening or hostile where Phillips felt that she was in imminent threat. She participated in a post-argument meeting with Regina's supervisors.
And then went to the police.
And then went to the police. And so, again, there was an investigation, and Regina had the police reports. Just because somebody makes a police report doesn't mean that it's racially based employment discrimination. It's a workplace dispute. There are police reports made by disgruntled individuals, employees all the time. I get those phone calls, and we work through the process. So, they also say that the background checks were faulty. Well, the point is, there was an investigation, there were background checks made, and if it's not illegal to hire someone. They didn't have subpoena power. They really take issue with the background checks, but again, it's not a genuine material issue of fact. Again, I pose it here that the Terrells were treated the exact same way with regard to the progressive discipline policy. In fact, Terrells, about six months later, were discharged for attendance issues and attitude issues. So, again, but they had progressed down the line. The incompetence argument is also, does not create a genuine issue of material fact. Being late is not racially motivated. If everybody's late. And in fact, Frazee and Phillips also received similar disciplines for attendance issues. Based upon the above, there is no foundation for negligent hiring. And in fact, the case law from the Supreme Court under Clausen says that in this situation, a negligent hiring cannot stand. With regard to a reverse discrimination and a hostile work environment, this is not a severe, pervasive, racially animated workforce. This was, people got upset. There was an incident. Management reasonably took steps to address the individuals in an immediate meeting afterwards. Phillips' shift had ended, so she properly went home. And she complained that she felt threatened, and Regina properly said, well, if you're feeling unhappy, don't come into work anymore. At which time she resigned. So this is with that.
Guys, I'll note your time is up, if you might
Thank you.
briefly conclude.
Yes, and then the constructive discharge, the resignation, and the lack of a hostile work environment that was severe is also a fatal flaw.
Thank you.
Thank you.
You'll have about 3.5 minutes for rebuttal.
Thank you, Your Honor. First, I'd like to just note that a nervous giggle by Ms. Phillips in the break room when she was confronted does not mean she was not scared or intimidated. In fact, the testimony in the record is that Ms. Phillips followed Mercedes out because Mercedes wanted to take it outside and beat her up. She said, I'll beat your asses. Let's go right now. So Ms. Phillips and Ms. Frazee followed Mercedes toward the elevator to fake her out, and then ran to Mary Freeman's office to tell Ms. Freeman what was going on because she wanted help. She was scared. That little conference they had in Ms. Freeman's office right after the incident was not an investigatory meeting. There were no interviews. Everybody was yelling, and Ms. Freeman, the testimony is that Ms. Freeman said, hey, I can't handle this. I can't do this. You guys go home. Mercedes, Ms. Baker, you go back to your shift. The other two, you go home. We'll sort it out later. Someone will call you Monday, actually. Well, the only thing that happened Monday is she was told to stay home because she reported to the police that she was scared. So, I also want to point out that just because Ms. Phillips worked for a number of months or years with Regina does not mean that she wasn't being discriminated against. Being able to work and fulfill your shift doesn't mean you're not being subjected to discrimination. Both women, both Ms. Frazee and Mercedes filed police reports. I want to point that out. It wasn't just Ms. Phillips. Both women went to the police after the January incident, filed police reports. Attorney Good stated that Ms. Phillips resigned before Regina could take any action, that they had no decision to make. Well, as Judge Carr pointed out, they had made their decision. And They did not fire Ms. Frazee until after that January incident, nor did they start writing up the termination paperwork for Ms. Phillips until after that incident. I want to reiterate again that Ms. Phillips did report the rude comments being made by Mercedes to her nursing supervisor, Ms. Freeman. But she also testified because Mercedes had family working there, she was scared and intimidated to do anything more than just mention it to Ms. Freeman. She also testified she felt targeted by the black employees who would not assist her with her workload. They were disrespectful, rude, and unhelpful with her. Yet none of this was brought by Ms. Freeman to management's attention. With respect to the investigation, Mr. Yantek testified that he recalled no investigation after receiving Ms. Phillips' resignation letter or any steps that Regina may have taken to stop the harassment. This is the executive director of Regina, Mark Yantek. That's significant. Despite the incident being described as he said, she said, Ms. Haynes, who was the one that was charged with obtaining statements, only obtained a statement from Mercedes. Only Mercedes. And she didn't even ask Mercedes whether she used the language that was reported by Ms. Phillips and Ms. Frazee. Ms. Freeman was not asked to investigate the use of the term white cracker or any of the other racially derogatory terms.
How about now your time is up if you agree
Thank
to
you.
conclude?
Yes, I'm ready to conclude, Your Honor. Thank you very much, and we'd ask that the trial court be reversed and that Ms. Phillips have her day in court before a jury.
Thank you.
Thank you.
And thank you both for your presentation today. The court will take the matter under advisement and will issue a decision in due course. That decision will be mailed to you by the clerk of court when it's released, and also be in the high Supreme Court website.